All right, next case will be Anthony LAMANCUSA versus Department of Revenue.
Good morning. My name is Elizabeth Harris, and I'm here on behalf of Mr. LAMANCUSA. The department
How much time would you like for rebuttal?
7 minutes, please. Thank you.
Okay, thank you. You may proceed.
In their brief, the department has agreed or acknowledged that the trial court's reasons for finding the subject matter jurisdiction was lacking, that actually the statutory requirements were met. So what I'd like to do is focus on this department's position that the trial court lacks subject matter jurisdiction to modify the amount of the child support, but lacked subject matter jurisdiction to modify the duration of the child support. And what I'd like to do first is kind of talk a little bit about what the purpose of the UIFSA is intended to do. It's intended when a foreign judgment is domesticated in Florida to allow that state here, New York, that has lost that continuing exclusive jurisdiction, for Florida to then possess that subject matter jurisdiction. And if we accept the position of the department here, we're left with the question, then who has subject matter jurisdiction to address the duration? The statute tells us that you can modify to the extent that the issuing state would allow that to occur. So what I would like to do is look specifically at the statute. The department tells us that subsections 3 and 4 of 88.611 specifically withhold jurisdiction. And what I would like to do is just take a real close look at what the language of that statute, those two provisions of the statute, say. Subsection 3 says, a tribunal of this state, Florida, may not modify any aspect of a child support order that may not be modified under the law of the issuing state, New York. So that tells us we can't modify, Florida can't modify duration, but to the extent that New York allows that to happen. That's a choice of law as opposed to restricting jurisdiction. Subsection 4 tells us, in a proceeding to modify a child support order, the law of the state that is determined to have issued the initial controlling order, New York, governs the duration of the obligation for support.
Let me ask you this, because I don't think it's raised in either brief, but that law was enacted by the legislature in 2011, which is prior to the judge's 2013 order.
Right.
But I think if you look at the statutes, it says that it becomes effective when Congress does a couple things. I mean, I believe Congress didn't do those things until 2014 or so, so I'm not even sure those sections apply.
So if I'm understanding your position, that 88...
But it's a really quirky situation because the legislature adopted the new subsection 3 and a brand new subsection 4 in 2011, but there is language that it becomes effective when Congress either amends section 666F to allow or require states to adopt the 2008 version of the Uniform Interstate Family Support Act, or 90 days following the state obtaining a waiver of its state plan requirement under Title 4D of the Social Security Act. So it says it becomes effective when Congress does something. So, but it seems like you both argued, both below and here, that those provisions, that the amendment had already occurred. I'm just not sure they are, and if they hadn't, where does that put us? Is the issue waived or what?
Well, I have two takes on it. I think in large respect, it may not necessarily matter because the intent of the UIFSA was adopted in Florida, I think it was 2007.
Okay.
Regardless, the intent, the purpose of this one order system, the continuing exclusive jurisdiction, the methodology to allow that to happen when you have an issuing state coming to Florida to avoid the forum shopping that the intent of the statute was all designed to do, that would be in place even if these provisions, in fact, had not been adopted. And it became a question then of choice of law because we would be left with who has subject matter jurisdiction. We're going to have this abrogation of the continuing exclusive jurisdiction if we give New York subject matter jurisdiction over duration. It simply doesn't conform with the intent of the statute.
So your argument is it's choice of law provision, not a
Yes.
provision that goes to subject matter jurisdiction.
Yes, sir. It's a choice of law. It's a question, and we have that determination made by other states, which are cited in my brief. And if we ignore those opinions, we've then ignored the direction from the legislature in Section 889011, which tells us the statute should be adopted and applied, construed and applied, rather, to effectuate that uniformity among the states. So we have two states, Washington State and New Hampshire, that have said this is a choice of law. Yes, you cannot modify it, but to the extent that the issuing state permits it. So it may or may not have been modifiable. That issue wasn't presented to the trial court before whether they could have modified in New York, but New York was the controlling law over the duration. But we have an issue as to whether Florida could, who has the subject matter jurisdiction, because there was an appeal taken of the order that modified duration. And that would be the determining factor. If we were here several years back, we might be in a different position. But we had a final order that the court had subject matter jurisdiction. It's only that basis that would have removed from the court's ability to do that. I think the statute, to split the ability of the court to hear a portion and not the other portion, abrogates the continuing exclusive jurisdiction of the court. In addition to that, I think we had some other issues with what happened below. We have a 1540 basis for which there was never a motion filed. So my client goes and is unprepared to address 154. He thinks he's there on a motion to terminate a prior order which was not appealed.
But the judge gave everyone opportunity to argue, to provide supplemental authority, et cetera, and certainly subject matter jurisdiction can be raised at any time, even on appeal.
Sure,
For the first time.
it absolutely can. But I would disagree that there was an opportunity. I think when you look at the record, the court actually seems to be agreeing with the position that I'm asserting today.
But then the judge says to both sides, send me case law. And
No, I have to be honest with you, I don't remember it that way. So I'm going to
that's
defer
what happened.
to you. I don't remember it that way. My recollection was that there was some suggestion that they would speak to perhaps the general magistrate as to his take on it, but
the judge
I'll defer to you on
judge
that.
didn't rule at the hearing. The judge ruled sometime after.
Subsequently, and seems to have gone down a path that wasn't addressed at the hearing and seemed to be contrary to the path he was suggesting at the hearing, which was in fact that this was a choice of law issue as opposed to a lack of subject matter jurisdiction, which, as I've said, I think that would be the position because then we're at a contrary, we're in conflict with the uniformed intent of the statute. Who has the jurisdiction? And do we not then have not a one-order system, but a multi-order system? I'm going to defer the rest of my time.
All right. Thank you.
May it please the court and counsel, my name is Carrie McNair and I represent the Florida Department of Revenue in this appeal. I I believe that I'd like to clarify what the department has agreed to regarding subject matter jurisdiction in this appeal. The department has agreed that UFSA applies and has argued that that UFSA applies to this case. However, the department has presented its argument that FICSOA, UFSA, and Section 88.611 Florida statute prohibited the lower tribunal from changing the duration of appellant's child support that was initially entered by the state of New York.
They argue that provision just says you have to apply New York law, that it doesn't say that you're not allowed to modify duration. What's your response to that?
UFSA is a jurisdictional statute. It provides instruction to the lower tribunal, to the states, regarding jurisdictional issues. And UFSA provides those jurisdictional issues to the state in order to create uniformity regarding the states. Florida has enacted Section 88.611 in conjunction with UFSA to make sure that the jurisdictional requirements of UFSA are met and are furthered in this state.
Let me ask you this. If, say, after the New York judgment got registered in Florida, 2013, 2014, 2015, somewhere along the line, the party's child gets arrested and is sent to, a juvenile facility until they're 19. That would be a substantial change in circumstance, right?
It would be.
Okay, and it'd be a basis for the father to say, I shouldn't have to pay child support to the mother because the child is now in the state's care. That'd be a basis, right?
The father could file for modification in the state of Florida and attempt to
Okay,
lower
well,
the child
that would be
support.
modifying the duration, wouldn't it? Where would the father have to file? Would he have to file in New York? Would he file in Florida? Or where would he file his modification action to reduce the duration under the hypothetical I just gave you?
The parties could agree to modify the duration in New York.
Well, wouldn't New York have lost exclusive jurisdiction because none of the parties lived in New York?
Yes.
All right, and so if the mother is not willing to agree to everything because she wants to continue to get child support, where can the father file a modification action under my hypothetical? Could he file it in Florida?
He could file it in Florida, but would Florida understand New York law regarding duration of the
Okay.
child support order?
So then Florida would have subject matter jurisdiction to modify the duration of his child support obligation under the hypothetical I just gave you.
Florida does not have jurisdiction to modify unless the state of New York would modify.
Right.
Right.
Okay, but for jurisdictional purposes, a New York court could act. They may act right, they may act in compliance with New York law, or they may screw up their decision and not act in compliance with New York law. But would the New York court have jurisdiction to decide the case?
The New York court would have jurisdiction, yes.
Well, how about the Florida court?
The Florida court does not have jurisdiction to modify duration of the child support.
Even under the hypothetical I
USC.
gave you?
There are, even in that hypothetical, the parties have to return to New York to modify the duration.
Why would they have to return to New York if you have the orders registered in Florida, the father lives in North Carolina, the child lives in Florida, and the mother lives in Florida?
Because New York law governs the duration of child support.
Right, but Florida could apply New York, a Florida court is allowed to apply New York law, right?
Yes, Your Honor.
Okay, all right. Okay, go ahead with your argument.
Let's say for a moment that New York law would allow a modification in duration. Is it your position that the father could have, in that case, filed in Florida for a modification of duration, pointed to the New York law, and the Florida court would have had jurisdiction to make that change in duration?
No, sir, it's not. Because UFSA doesn't provide the Florida court with subject matter jurisdiction over duration of the child support,
In any case?
in any case.
Doesn't the language of subsection 3 seem to indicate the opposite?
Yes, sir. The language indicates that The language indicates that modification cannot occur unless the state of New York allows for modification.
New York law.
Yes, sir, unless the state of
So
New York.
doesn't that sort of suggest that a Florida court could
Right.
modify duration, assuming that New York law allowed it?
I understand where the clause in that law allows for that confusion. However, the UIFSA statute has provided subject matter jurisdiction. It's the department's position that the state of Florida does not have the authority, because of the UIFSA proclamation, to alter the change of duration.
Even if New York law allowed for
New
a
York
modification
law.
of duration?
Allowed for a modification.
How do you deal with the New Hampshire case? It's in matter of Ball, I believe.
In both cases presented by counsel, in Ray Matterball and also the case I presented, Schneider, they also cite that other cases where other states have determined that UIFSA only provides a change in duration, that UIFSA does not provide subject matter jurisdiction to the court for change of duration in the state. Jurisdiction has to be provided to the court in some regard. It's not provided in state law, it's not provided in UIFSA, it's not provided in FCSOA. So in regards of where it's provided, there's not any indication that it's been given to the lower tribunal in any of these laws.
What about subsection 1? Father lived in North Carolina, mother lived in Florida, correct?
The father lived in North Carolina, the mother lived in Florida, yes.
So isn't there jurisdiction conferred under subsection 1?
There's jurisdiction to modify the amount of support. There's not jurisdiction to modify duration. I mean,
Well-
UIFSA applied, and the department has conceded that UIFSA was in play in terms of the modification being allowed here in Florida under the amount. It's simply the duration that the department has argued that UIFSA does not provide a subject matter jurisdiction for duration.
Or then going back to subsection 3, how do we read that to prohibit a trial court in Florida from modifying duration? When New York law allows for a
Would
modification?
allow for it. And I don't believe that there was any argument or any position taken below that New York would have allowed for this modification. I mean, there's no argument that Florida could modify and New York had a good basis to modify here. I mean, the facts of this case are that appellant applied for a change of the amount of his child support. He didn't request in his pleadings to have the duration changed. The duration was inadvertently changed once a final order was entered using standard language from the documents that the Florida courts generally use. And even if this court wanted to review whether or not he had grounds in New York to change the duration of his child support, the facts were not presented below, and that argument wasn't presented below.
I'm not sure we need to, though, right? Because we may be talking about the difference between legal error and a lack of subject matter jurisdiction.
Yes.
And so perhaps in this case, New York law didn't allow for a modification of duration.
Right.
But if the trial court nevertheless had subject matter jurisdiction and either didn't look at New York law or misinterpreted New York law, then wouldn't that be legal error instead of a lack of subject matter jurisdiction?
The only two cases that have been presented to argue that the UIFSA's proclamation would involve legal error versus subject matter jurisdiction are the N. Ray Ball and the Schneider case. Even in those cases, there is case law indicating that UIFSA has generally presented jurisdiction only for the amount of the child support to be changed and not for duration. Other states have long held that jurisdiction is only presented for a change in the amount of child support and not duration. You know, is the law starting to change? Are courts going to, in the future, determine that it is legal authority versus subject matter jurisdiction? In those two states, yes, but in Florida, there hasn't been a Florida order instructing the circuit courts on whether Florida will continue to see the subject matter jurisdiction issue as only pertaining to the amount of child support and not duration.
Let's talk about just the statutory language for a moment and sort of leave case law behind. What is the legal argument based strictly on the statutory language at our disposal that the trial court lacked subject matter jurisdiction here?
The statutory language that you're referring to is in addition to what UIFS has already presented, what UIFS has already provided to the states. I think that statutory language in Section 3 is instructing the court that that they're not allowed to change the duration of the child support. You know, the language indicates to the circuit court that duration cannot be changed.
The phrase in subsection 3 that may not be modified under the law of the issuing state. If the trial court doesn't have subject matter jurisdiction to modify duration, why is that phrase in the statute?
The phrase is, you know, the language of section also explains to the circuit court that duration cannot be changed.
Well, if that was the case, wouldn't the statute just say a tribunal in this state may not modify any aspect of a child support order, period, and leave out that second part of the sentence?
I believe the lawmakers were trying to epitomize what was in UIFSA. I think that sometimes information is included that leads us to believe a different outcome. But I do think that they were trying to epitomize what is in the grounds of UIFSA, and UIFSA never expected states to be able to change the duration of the child support. And in this regard, the appellant never presented any argument or evidence that he had any reason in New York to change the amount of the duration of the child support either.
Do you at least agree that the language of 3 seems to indicate that
Yes,
a trial court can, in certain circumstances?
I do agree that the language is confusing, yes. I do agree that it encourages the circuit court to change duration of child support if a party has presented the argument that it can be changed in another state.
And so if that's what the statutory language seems to say, how do we not apply that as the legislature wrote it?
There hasn't been an opinion in Florida as to whether UIFSA provides only subject matter jurisdiction for the amount or also duration, because there hasn't been an opinion providing clarification to the court.
Well, does case law control here, or does the statute control?
The statutes control over case law.
So how do we not apply the language of the statute as written by the legislature, even if the legislature...
I don't think the language of that statute is authorized, is not requiring that the circuit court amend duration if another state's law allows it. I don't believe that statute requires that the duration be changed. I don't believe that if appellant had presented an argument that New York allows a duration under these circumstances, I don't believe that it requires that the court alter the duration at that time.
But it doesn't prohibit it, correct? The language doesn't prohibit it.
Confusing, but UIFSA prohibits it. But what prohibits it is subject matter hasn't been granted to the circuit court by the statutes, by UIFSA, by FIXOA. So there would be no grant of jurisdiction to the circuit court to change duration.
And now we're back to the original question, though. Didn't the trial court have jurisdiction because I think it was one of them lived in North Carolina and the other lived in Florida?
The father lived in North Carolina, the mother and child lived in Florida. All of the parties had exited New York.
So the trial court had jurisdiction?
Had jurisdiction to modify the amount of the child support, but did not have subject matter jurisdiction to modify the duration.
All right, any other argument?
Your Honor, it's always been the department's position that subject matter jurisdiction has not been specifically granted by statute or by law, and that because subject matter jurisdiction to change duration was not granted, then subject matter jurisdiction to change duration does not exist. When appellant requested that he modify his support obligation, he sought only a modification of the amount. He presented to the court that he wanted to alter the amount of his child support and did not request at that time that his duration be altered. But for the inadvertent language in a standard Florida appellate court, his duration of support was mistakenly modified by the court in their final judgment. Once he filed his petition to terminate his child support, the court then determined that his duration of support had been mistakenly modified and then denied his motion to terminate in that regard. Appellant presented no arguments that he was entitled to a modification of duration for any reason at all. The state of New York requires that child support be paid until the child turns 21 years of age. And in this case, by allowing the final judgment to change the modification, to modify the duration of the child support, the child has lost 3 years of child support that otherwise would have been required by the New York order. I don't believe that the circuit court intended to modify the child support to lower the child support by 3 years. I believe it was done inadvertently and mistakenly. And it was only corrected once the motion to terminate was filed and then denied by the court.
Counsel, isn't it correct that the ability to correct that error has long passed? It was not appealed by the Department of Revenue, even if it was a mistake in the order? And the only way that the Department of Revenue can challenge the 2013 judgment is to claim that the court lacks subject matter jurisdiction.
It is true that a 1.54 motion was not filed by counsel within a 1-year time period from the date that the final judgment was issued. However, because the department has argued the lack of subject matter jurisdiction over duration, the department argues that the order can still be challenged. A void order can be subject to challenge at any time. If this court rules that the department was required to file a 1.540 motion within 1-year time frame, we can't change the facts that we have. A 1.540 motion was not filed. I would like to reiterate that the parties were divorced in New York. New York requires a child support order to be paid until the child turns age 21. Appellant presented for a modification with no facts supporting his change in duration, and except for an inadvertent error made by the circuit court, was not entitled to relief in the nature of which he requested. Because the circuit court inadvertently provided him with relief, the termination motion was filed, and the court ultimately was attempting to ensure that the law was enforced in terms of requiring that he continue to pay child support until the age of 21.
All right, any other argument? Any other questions?
No, sir, thank you.
All right, thank you. All right, rebuttal.
I think what we have here is some muddying of subject matter jurisdiction. So I often, when I consider subject matter jurisdiction, I go back to my law school professor that explained it to me in a way that stuck 27 years later. So if subject matter jurisdiction is the train, that's the type of case the court can hear. Mr. LAMANCUSA had the ticket to get on the train. He lived in North Carolina. The wife and children lived in Florida. So he had the ticket to get on the train. Now, the question of choice of law was whether he got to sit in first class or he got to sit in the coach seat. So he's on the jurisdiction train. That resolves this matter. This is the type of case that Florida can hear because New York has lost the exclusive jurisdiction. He has the ticket, he's on the train. Now, where he can sit, can he modify duration? Can he modify the amount? Becomes the question, a choice of law. So I believe that's what we have, and I think the statute helps us see that this is a question of law, whether he could have modified in the duration in New York, and the Florida court could say yes or no, you can under New York law. Now, the last point I want to make is the cases that are cited in my brief, Ball and Schneider, they do reference other cases. And the department made a comment in her remarks that there are other cases that say the issuing the new state does not have jurisdiction, and I would say that those cases don't say that. They say the new state, the subsequent state, can only modify to the extent that the issuing state allows. That's the case law as it stood up until Ball and Schneider that addressed this issue for the very first time. Those two cases determine whether the modification of duration is a choice of law or a choice of subject matter jurisdiction. Both those cases tell us it's a choice of law. And here in Florida, we look to the other states based on what the statute tells us to do.
Yeah, any other questions? All right, thank you. All right.